You're live.
Hey, wealth builders, Simon Dixon here. Today, we're going to be doing a pretty technical update to Celsius Creditors. The reason is because we have had so many different updates that have been happening, and there's a lot of questions out there. Now, the UCC are going to be going live with the town hall, and we'll do an AMA after this on Twitter Spaces this week. We'll be going live after this, and then the UCC are going live on Thursday. But what I wanted to do is really just get the information in one condensed video so that, because this has become a very technical subject, and really the last 8 months that we've gone through as creditors and trying to understand the relationship with shares is really unearthing as this whole case progresses. Now, I do need to warn you, I have a sore throat. I'm feeling a little bit under the weather, but I really wanted to get this live in time. So if I have to stop suddenly for a little coughing fit, I've got my water, I've got my cough sweets, and I'll do everything I can to make this as fluent as possible. I do have some slides to go through. If you're not a Celsius creditor and you're a complete financial geek like me, then you might find this interesting because I'll go through some of the history with Bank to the Future, Celsius, myself, Alex Mashinsky, and a little bit of the drama, not to go through the drama again, but because it's all become relevant in what happens next, so that everybody can unpack the information and make better decisions, because you're now going to have to actually fill out claim forms and sue various entities within Celsius in order to try and get the recovery that you want as per the advice of the Celsius UCC. Right. So sorry if it's a little bit technical. I'll put a bit of drama in there for those of you that are not Celsius creditors, but it's going to get pretty technical into the case. And if you're a financial geek like me, you may enjoy it. If not, then if you are a Celsius creditor, it's vital that you go through this, try and unpack the information. But remember, I'm not a lawyer. I'm not a financial advisor. Whatever happens next may impact your recovery. It may impact what happens. And it's got very, very technical with some of the best lawyers and most highly paid professionals in the world working on this case, of course, all paid for by creditors like myself and you, if you are also one. Okay, so bear with me while I go through this. Every slide is relevant, even though sometimes we've got to actually unpack some of the conversations that I had in very confrontational formats with Alex Mashinsky in the past, just so we can understand and make an assessment of what happens next. And so some of you may be Bank to the Future shareholders, but all of the Bank to the Future shareholders were also Celsius creditors, because we facilitated the funding round where essentially Celsius went out to their customers, made them shareholders. And so I just want to make sure that everyone understands what comes next. And obviously all the disclaimers that come around that. I'm just not a lawyer. I've just done the research and I'm trying to unpack information for you so it can support you in your claim forms and understanding what comes next. So I'm going to go to a screen share now. And hopefully you can see my screen. Azad will let me know if that's not the case. Oh, hold on. I need to unshare because I need to make sure that the sound comes through, because at some point I'm going to play a video. Right. I've ticked the right box. I'm going to play the slides now, and I'm going to jump in and go through some of the information. Right. Okay. So this is, as I said, on the claim forms and structure so that everybody can understand what the current situation is, because unfortunately there's no simple way of explaining, because this has gone down a very complicated route. Again, not legal advice, not investment advice, not tax advice. You have to seek your own counsel. I'm just providing educational content from the research that I've done so that you can utilize that in trying to understand what you're going to do and what your next moves are. Okay, so here was the announcement from the Celsius UCC. The Celsius UCC essentially was telling us that creditors only have a claim against Celsius Network LLC, and that shareholders and they invested into a different entity, which is Celsius Network Limited. One is a UK company, Celsius Network Limited. You know that because UK put limited at the end of their companies when it's limited by guarantee. And in the US, they use LLC and Inc. to represent different types of companies. Well, when you signed up, and I'll go through so that you understand the difference, but also, even though you only have a claim against Celsius Network LLC, you do have the right to sue for fraud, mismanagement, negligence. And I've taken some of those words from the UCC because obviously they think those are the important words, and that, not legal advice, will have to be reflected in your claim form. And they have extended the bar date, which was previously the 9th of February, to the 28th of April in order to accommodate this. So to help you understand that, let's jump straight in so I can try and unpack this for you and hopefully do a job of explaining this. So let's first go through the timeline and background because it's all relevant. Everything we've experienced over the last few years and the last few months since the pause in Chapter 11 has suddenly become relevant. I'm going to play some old videos as well because it helps us understand what the different parties were thinking. So if you didn't read the examiner reports and you want to be caught up and up to date, because this has now become a fraud, misrepresentation, and all sorts of allegations, it's important to understand what's happened. So in a nutshell, you can read the 600-page examiner report. But in 2018, Alex Mashinsky misrepresented that they raised 50 million in an ICO and 18 million wasn't subscribed to. So he agreed to subscribe to it, never paid for it, and tried to uncover it through paperwork in order, because they were scared that people, if it was undersubscribed, that would cause an issue. So that was the first kind of misrepresentation. Now let's forward a couple of years. In 2020, Alex Mashinsky comes to Bank to the Future. We decide to do the Series A because he wants his creditors, or not as now, but his customers, to become shareholders, and we provided the technology to facilitate that. But what he pitched was an institutional lending platform to us, which is, from our understanding, what the platform was doing at the time, and all the representations were made that that's what Alex Mashinsky and Celsius are doing, institutional lending. But it was after the Series A that a big pivot happened and a lot of the trouble started to happen. And so by 2021, the business essentially pivoted away from investing to investing client funds and becoming more like a hedge fund. So rather than just being an institutional lending platform, it actually started making investments in private equity, mining companies later, DeFi, lots of other stuff, under-collateralized loan, no collateralized loans, loans collateralized by tokens, which are very volatile, and DeFi, and then handing it over to a fund manager that wasn't actually regulated to do any of those activities. And that's where all the issues occurred. So this is what we would call, not a lawyer, but negligence, essentially, misrepresentations as well. And then, unfortunately, lied on all of the weekly AMAs about what they were doing and the safety and the risks involved and the regulatory compliance and all sorts of stuff. And then ended up with $1.3 billion of yield that was paid that was never earned. So it was represented as, an 80-20 split where, based upon these loans, 80% of it goes to the customers and 20% is left for the company, and created a pump and dump because a lot of the money, client money, was used in order to push up the price of sell token. So this is where the fraud accusations, misrepresentations, and negligence that the UCC said. And also in court, Kirkland and Ellis said, we're not representing, any of this anymore. We want that to go to the litigation trust because we believe creditors get and deserve to sue for all this stuff. And so in 2022, essentially the UK regulators came after Celsius and said, you're offering unregistered securities, you're not in compliance with UK laws. And so they had to leave the UK and set up and created a new structure where intercompany loans were set up. And this all becomes relevant to where we are today. Once they had those regulatory investigations, it's set up in the US. And then they did a Series B investment. Now, those Series B investors are currently involved in the Chapter 11, and they believe that they were misrepresented as well, that they were sold a mining investment as opposed to a consumer lending. Now, It was then put out to everybody that the big Series B investors had done all the due diligence, and that was used as a reason by Alex Mashinsky to try and put safety into creditors that are now become creditors. And so that was another misrepresentation to the Celsius Series B. And so those investors feel pissed as well. Also, they didn't register with any of the US regulators other than the very basics, which was as a money service business. Now, that's not actually a license. That means you voluntarily tell FinCEN that you're going to comply with AML regulations. And then they started getting some state-by-state lending licenses, and they started to look at money transmitters retrospectively rather than before offering the service. And so obviously this led to cease and desist orders. There was an SEC investigation that came saying that you're offering unregistered securities. That was never resolved before the Chapter 11. So they went into Chapter 11 protection. But state regulators did actually send a cease and desist. So various regulators came along and said, you can't offer these unregistered securities. You're in breach of securities laws. And so Celsius stopped offering to those states and created a custody service that paid out no yield. Then some of those other state regulators then came along and said, you're not regulated in order to do a custody service. You don't have the relevant registrations. And so they created this withhold service that was settled with this week. And both those custody, so then you have these three things: earn, which is those that were receiving yield; custody, which is those that are reaching a settlement; and withhold, which is those that are reaching a settlement due to not being able to offer the custody service. Okay, so this is probably the negligence comes in, again, not a lawyer. But then in June the 12th, as we know, 2022, they paused withdrawals and then filed for Chapter 11 protection in July the 13th, 2022. And that later led to an examiner report, which actually becomes very important given the current situation and what comes next. So that's the timeline. And now I need to cover a bit more of the history so that we got everything. Right, so obviously Alex Mashinsky had to resign because the UCC did an investigation into everything, pointed out all the fraud, negligence, misrepresentation, and managed to get Alex Mashinsky to resign. And now Celsius is not controlled by Alex Mashinsky, but he held on to one of his positions and his shareholding. So this all becomes relevant as we unpack this. So that's really the background. And then we can understand what comes next as we start to go through this, and why this leads to the claim forms and everything that we've now got to do. Now it's got very complicated. So he resigned after the UCC investigation for all of those reasons. And I want to play you a quick video. For those of you, sorry to give you post-traumatic stress disorder when you hear Alex Mashinsky's voice, but I just want to play you a video when Alex Mashinsky came out and broke his silence. We ended up in a very confrontational recording on Twitter Spaces, and it reveals quite a lot. So I'm just going to play a little clip of that. Everything we have published, we recorded everything that happened throughout this whole case, because if anyone wants to go back to it, we can see everything, and good job we did. So I'm just going to play that video, and on the right of the screen, you'll see some of the different things that Alex went through that reveals some of the different, negligence, misrepresentations, lies, and various other things, because this all becomes important for your claim form. Okay, again, not legal advice, but I'm going to take a quick water break while we play that video. So hopefully you can hear that now. Again, apologies for PTSD from hearing Alex Mashinsky's voice. But here was the Twitter space all that time ago, months and months and months ago, when, before Alex actually got forced to resign.
Alex, how much did you invest into the ICO, and did you repay that loan?
I can't answer any of these questions right now. All of that is public information, okay? So if you have any questions, again, the UCC and everybody else will be publishing all that information for everybody to see. There's no secrets, okay? The issue here...
Did you ever repay that loan?
You keep redirecting, Simon, you keep redirecting. You're not answering any question that anyone is posting. Redirecting, okay? So again, the filings by me and Daniel are not in any way saying that the equity is worthless. Okay, in no way is that what it's saying.
Okay, awesome. So Alex, how are you going to make our equity worth something?
As stated before, we submitted a plan to the UCC. You guys are all represented by the UCC. You need to ask them to tell you what's going on.
So
okay?
Are you favoring equity holders over creditors right now?
No, not at all. We submitted.
So how does our equity become valuable when then it owes so much to our
submitted
creditors?
a plan. We submitted a plan. Do you have a plan? You don't have anything. So if you have a plan, submit a plan. Otherwise,
I'm
stop
following
talking.
I'm following the process, Alex, and you know it.
Following the process is submitting a plan.
Who do I submit the plan to?
The UCC.
No, Alex, answer that. Who do I submit the plan to?
If you want to buy something, then you go to the bankers. If you want to solve the problem, you go to the UCC.
And who was it that told me that I need to go to the bankers rather than the UCC?
Simon, come on, okay? You keep misrepresenting things, okay? And everybody
Alex,
knows it.
What do you, Alex?
You just said it. I lied on every MA.
Did you know that there was a hole when you called me and told me everything was fine?
Alex,
did you know that there was a hole when you told me
right?
to put more of my clients' retirement funds in your platform? Did you know there was a hole?
I cannot respond to any of these things because of the process, and all that information will become available.
So you understand that there's very compromising questions, right, that you put me through.
I cannot speak anymore, okay?
Alex, do you think it would have been good to give an apology to people rather than coming in and trying to make accusations last time you were on a call? And
the only person who made accusation was you. You just said I lied on every
Alex,
MA.
do you think you owe the community an apology?
I'm ready to apologize, okay? I'm waiting for lawyers to give me permission to apologize.
Okay. I think that would go a long way.
Okay, great. So there's various...
So why don't you guys just work together, Alex and Simon? I mean, Alex has his pros, you know. Simon, you have your pros. Leave the negatives out. Why don't you guys just work together?
Okay, well, I'll answer that question. Maybe Alex can answer. Alex, do you think there's a chance that regulators allow you to run this company in the future?
This is not about me. This is about a plan that works for everyone. Okay.
Yeah, do you think it would be more beneficial
You're the only one who's making it about me. Everybody else here is about a plan. Look at the title of this. Look at the title of the session. It's about a plan for recovery. So you want to talk
Alex,
about that?
Did I come and give you a plan and present it before this went into Chapter 11?
Okay, cool. Sorry. I'm talking over myself. Okay, that's the video, right? Okay, so all of that is useful information in understanding months and months and months ago, you know, where we stand today as both either shareholders or creditors. So now I'd like to unpack some other information so that we can understand what is happening right now. So firstly, we had a bar date on February the 9th, and that date has obviously passed. And what we were assuming when we made this application is that we were doing what the UCC and everyone told us, that traditionally in bankruptcy, equity is lost. And so because there was a big hole, there's no value in the equity. And we were told by the UCC and various other advisors throughout this process that we have a claim over the whole group. Now, this is the whole group that was submitted to us in the original Chapter 11 filings. And what I want to do is simplify this so that you can just go into, there's a lot here because GK8 has been sold and various other things, and I could go really into detail like it has in many of the other filings, but I want to keep this as simple as possible for you to understand what I think you need to know so that you can then decide what your next moves are, whether you get counsel or however you're going to play this. So we thought we were filing a claim against the whole group, which is, you know, Celsius Limited, Celsius Network Limited, and all of its affiliated entities in the group. This is what happened though. Milbank, the certain investors in the Series B that had preferred shares over the Series A, hired Milbank in order to represent them, and they presented this different presentation to the judge. And on the March the 9th, the UCC told us that Judge Glenn has actually ruled in favor of the Series B shareholders. So what does that actually mean? What that means is, I'm going to dig a little bit deeper into it, but you can see what the UCC said, that creditors now have a claim over only the company that they sign the terms and conditions with, rather than all of the entities. And the shareholders invested into the parent company, but there was a bunch of intercompany loans. So I'm just going to dig deep into those as well so that you can understand. But it's not quite that simple, because all of the creditors can end up suing all of the other entities for all of the fraud, misrepresentation, and everything that was covered in the examiner report, and some of these admissions when Alex Mashinsky apologized, so that we can utilize all of that in these different cases. And as you know, from day one, I've disclosed everything, exactly, how Bank to the Future did the funding round, the shareholder, the creditors, the different entities. I'll go through all those again as a reminder, because I disclose them all from day one, because I'm just trying to unpack this so that everybody can see where they stand and what the next steps are. So remember when I talked about that timeline when the UK regulators said you can no longer do business in the UK. Well, this is when Alex Mashinsky switched the terms and conditions, and Celsius switched the terms, and essentially said that Celsius owns all the assets, the funds you are lending to Celsius, and in case you are an unsecured creditor, all of those different things that have been fought over the different court case to where we are now. So this is an extract from Milbank's slide where they were making their case as the Series B shareholders that was used in order to make that judgment. And so this is what transpired after we invested in the Series A, obviously. So let's now take that cap table on the public disclosure, and let's dig a little bit deeper so we can understand the different relationships. So the first relationship is creditors. So all I've done is I've zoomed into that cap table a little bit and taken out some of the noise. But you'll notice when you signed up to the terms and conditions, the terms of use on Celsius.network, if you ended up depositing funds, you would have signed up to these terms and conditions with Celsius Network LLC. Now you'll notice that it sits underneath the mining company, and it sits underneath the main UK company, which was originally where they were doing business. But now it turns out that when you sign those new terms and conditions, you had a relationship with an entity a lot further down the chain, which is Celsius Network LLC. So, and that's who you sign the terms and conditions with. Now you'll notice it said and its affiliates, but Judge Glenn ruled against that for various reasons. So that's the creditors relationship. Now the shareholders, both the Series A originally invested into the UK company, and the shareholders in the Series B also invested into the UK company, but they invested into the restructured entity, whereas Series A were forced into a restructuring. Now, the shareholders never signed the terms and conditions unless, of course, they were both a shareholder and a creditor. And so this makes immense complications in the process. So the shareholders would have signed a shareholder agreement. Here's a copy of, the Bank to the Future side, just to show that. I haven't gone through all the details there, but their relationship was with the UK company, Celsius Network Limited, right? So you've got LLC, they call it, and CNL. Shareholders had the relationship with CNL, and creditors had the relationship with LLC. There becomes other importance as well, because there was all these intercompany loans. So remember, with the UK, when the regulators said, you can't have client funds here, you're not a regulated custodian, you never applied for the licenses, They then had to make an intercompany loan to satisfy the UK regulators. And this is where none of the accounting records were essentially done correctly. We had this headline with Coinbase saying that 7,000 different transactions were unreported. Now, in the original filing, there was approximately a $9 billion loan where the client funds were lent between these entities. And these relationships are not clear, and we need the clarity as this all unfolds. But in the examiner report, it was said that the record keeping was so bad and so fraudulent that that $9 billion loan came down to a $3.48 billion loan because it was virtually forensically impossible to go through all the records and determine which entity was working with which transaction. But this $3.48 billion loan is essentially where the shareholders are in the money. And what that means is that if shareholders have more than $3.48 billion of assets, then they would be entitled to something, and everybody would then have to sue the different entities based upon fraud, misrepresentation, and negligence. Again, I'm not a lawyer. We can ask the UCC these questions later who do have lawyers, but I just want to share for educational purposes the information so that people understand it. There was as well with the mining company, Celsius justified taking client money by stating they were using it as collateral in order to take out loans. And so therefore they didn't believe they were spending client money. Because they used it as collateral, they took out $1 billion loan with Tether and invested in a mining company where somehow between these relationships, there was a $750 million loan between the different entities and the mining companies. So that also plays into this equation. Depending on the structure, the more clarity that the UCC can give, it would in unpacking those relationships to understand where this goes. Okay. What's the next relationship as well? Okay. Well, when Milbank filed their documents, they were showing that they were misrepresented a mining investment. And they were showing that there was an S1 because Alex Mashinsky and Celsius were going to take the mining company public. It was used where some of the shareholders' money seemed to have been used, and client money was used as collateral. And then this money was used to invest in the mining operation. But the mining operation was going to go public, and it looks like it wouldn't even have gone to creditors, is the argument that the shareholders are making here. And Alex Mashinsky wanted to use it to try and IPO, fill the hole, and then replace some of the funds that they'd YOLO'd away illegally for creditors, sorry. So this is where it becomes very important. Our case for fraud, misrepresentation, negligence, and various other things all need to go on the claim forms because we now understand these different relationships that Alex Mashinsky was essentially going to try and fill a hole, a fraudulent transaction, and therefore it misrepresented to shareholders. And then the mining company was going to go public and hopefully fill this multi-billion-dollar hole that he'd created. And then obviously it all went wrong when the loan got unwound. That locked in a big loss and everything that was covered in the examiner report. So that examiner report becomes vital to the recovery and also understanding some of these things now, because it looks like that was part of what was submitted to evidence from Milbank for the Series B investors. So in a nutshell, this relationship between shareholders who signed, with the parent company, which is Celsius Network LLC, CNL we'll call it, they have a different claim, and that was one, for the different mining entities, and the relationship with the customer was with Celsius Network LLC. Okay. So let's take a little bit, we need to go a bit deeper. Look one step up from the UK parent company. There's another entity that sits on top. So let's look at the shareholders. Now, the Series A investors, which was Bank to the Future and Tether, and various other investors that Alex Mashinsky misrepresented and took on directly onto their cap table, maybe. I don't think there was misrepresentations at the Series A stage, but at some point those misrepresentations came through. Celsius Network Limited has all of these shareholders. This is all public information, so I've just pulled it from the public information. Sorry, just putting in a cough suite as well because my voice is going. Also taking some water. Just for full disclosure, let's say who the important shareholders are. Excuse me. So the first important shareholder is Celsius Network Inc. They own vast majority of the company, 64.63%. Other shareholders are the Series B, which they think they're entitled to approximately 20%. Tether has about 7.73%. The Bank to the Future Syndicate has 5.37%. One of the special committee members, just for full disclosure, has a very, very minority shareholding. David Bosses and Alan Carr are on the special committee of Celsius Network, which would sign off on any reorg plan. And then others, I think Alex just started taking on investors directly during the Series B because they were waiting for us because we were trying to get the due diligence and we didn't get the due diligence we needed in order to go live. So that is the relationship of Celsius Network Limited in terms of shareholders. Now, remember there's one company above it. So what is the company above that layer? And again, you can go back. Well, there's that Celsius Inc. So who is Celsius Inc.? Well, Celsius Inc. is essentially, from what we can see, 83.67% owned still by Alex Mashinsky, who still holds a director position on Celsius Network Limited. So look at those two important topcos. You've got Alex Mashinsky and S. Daniel Leone own all of, from what we can tell, Celsius Network Inc. Now remember, about 64% of the company that is entitled to the mining operation and everything in the Series B belongs to the Celsius Network Limited, of which Alex Mashinsky held his one and only director position. He resigned from everywhere else, but he now has his shares and director position there. So all of this becomes important in understanding that relationship. And so when we're actually filing our claim forms, it's got a lot more complicated because Alex Mashinsky essentially is no longer a creditor from what I can tell, because he will be subject to insider clawbacks for all the money that he withdrew, and S. Daniel Leone as well, and then will be sued by the litigation trust, which is part of the reorg plan. Excuse me. All of his claims are going to be subordinated, as what we were told as part of the plan, which means that he's no longer a creditor from what I can tell. Again, not legal advice, but this is what all the documents seem to tell us. So Alex Mashinsky, from what we can tell, and all his entities are no longer creditors because of all the fraud and everything that happened. But he did keep his director position in Celsius Network Limited, and he is a shareholder of effectively 54% of the company. The way I calculated that is taking the parent company, where he owns approximately 83%, and I took 64% of that, and you end up with about 54%. So majority shareholder and director, but there is a special committee which the UCC said is in charge of that entity. So the UCC tell us that Alex Mashinsky as a director can't make decisions, and it would be violently opposed in court. But he is the majority shareholder and beneficiary to whatever is retained through shareholder value. Okay, approximately 54%. Now, what the legal relationship is after that, I don't know, but it helps us understand why the examiner report is so important to us, because this is what we're being asked to do now, is as creditors, we have to make claims, and shareholders, based upon the intercompany loan, whether they're in the money or out of the money, is what comes next in the case. And so if you look at, to get some clues, go to Strato and type in Alex Mashinsky, you'll find out that all of his claims, what it looks like, have 0 next to them in terms as a creditor. But again, not legal advice, do your own research here. But if you look at the company's share claims, and obviously all shareholders will be putting forward a similar claim, it's said that there is not 0 essentially. So this is what Alex was saying. The shares are not, because Alex Mashinsky obviously knew the misrepresentation, how it was sold to shareholders, the pivot over time. And so he's put in a claim for all of his shares in Strato, but he's put 0 for all of his as a creditor. So this kind of seems to reinforce that Alex Mashinsky is going after the shareholder value from what I can see here. Okay, so again, bankruptcy lawyers, please go through this and tell us what we need to know in the comment section. That would be great. So again, what is the outcome? Not legal advice. This is what it appears to me, the current situation. Shareholders and creditors are likely to have to settle in the upcoming case. This, I think, will be resolved in Chapter 11. So by the end of this, it will be known that, for example, if the assets are worth less than $3.5 billion, shareholders may be out of the money. However, it all depends upon those relationships, and the UCC and the shareholders and the judge will be going through all of this, and I believe it will all get settled within Chapter 11, and there are various things that are going. So, us as Series A shareholders, we would just, as a non-discretionary investor, we would just be going along with whatever relationships are there, whatever comes out of the Chapter 11 course. But we're saying that we as creditors only have a claim against LLC, as opposed to the parent company that has exposure to the mining operation. And so therefore, what goes into the litigation trust becomes important, because Daniel Leone and Alex Mashinsky and their actions in the examiner report becomes, I think, important. So when people are being asked to file a claim form, they have to talk about the misrepresentations, the frauds, and the various other things that happen. And obviously the examiner report is the perfect exhibit and document for explaining that. But the UCC is now advising that everybody needs to come after the other entities as a creditor, because that's where the case has gone as a result. So here's the important diagram, really. So remember, Alex Mashinsky and S. Daniel Leone own the top entity. 54% of it is owned by them, the entity underneath it, which is Celsius Network Limited, and the rest is Series B, and Series B are coming after, the money. There is intercompany loans between the mining and the way it was settled as a result of the fraud, and the fact that they didn't have the licenses in UK and then didn't have the licenses in US, all becomes very, very important for our claim form now. But we have a relationship, and so earn claim forms, they're being asked to submit a claim form whereby they are making a claim for their coins against Celsius Network LLC and that entity only. But they can also add, using an examination report as an exhibit and their own document, a claim for fraud, negligence, misrepresentation, and any other legal cases. So if you were caught in litigated loans and various other things that were never resolved, you have to include those under these different claims as well. Not legal advice, but that is what the UCC is stating. And then the rest will be determined in court. So also, we are going to be receiving, there is custody settlement, there is withhold settlement, all came through this week. We're probably going to see a document on the docket this week for the borrower's settlement as well. My understanding is that is all moving forward. I have personally spoke to at least 4 bid syndicates that are looking forward, and Nova Wharf themselves. We were moving forward with the assumption that this is going to all be resolved as well. So they're all moving forward based upon this being resolved in Chapter 11. So the borrowers, it looks like they have a claim form that they're going to submit against one of the lending entities. The earned creditors are going to submit a form against LLC. The shareholders have these out of the money or in the money And an auditor was hired to value all of the assets, which I think was about making that determination ahead of the disclosure statement of the plan that's being submitted by NovaWolf. And they're asking the regulators to put their objections in right now. I know it's complicated, but this is the current situation from my understanding. And so everything that has happened up until now has become vitally important. The examiner report is there. The evidence for fraud, misrepresentations, negligence is there. And the case against Alex Mashinsky, S. Daniel Leone, and the other affiliates has become vital for the recovery. And all of this is getting cleared up between whether the shareholders are in the money or out of the money in court. And we got an extension on the claim form so that we've got time for this to all figure itself out. And also the disclosure statement coming through. So we're going to have to do more spaces and AMAs because unfortunately this has got complicated. And on Thursday, the UCC will do their town hall. So they let us know that we have got an extension of the bar date until April the 28th. And everything that has happened up until this now becomes vitally important because we now need to all, from my understanding, submit claim forms. Obviously, you know that there was a criminal case from my perspective that Alex Mashinsky rugged about 289 Bitcoin. Celsius decided that that was something that needed to be corrected. So the updated forms have all gone through, and now we've got the claim form and new bar date. So just for full transparency, on Twitter, I put out there the PDF file with everyone's claims was put out as a PDF. That was extracted into a CSV to make it easy for people to use CSV data. I published this on Twitter. And also just to give you their full transparency, my claim has been updated to reflect the value that it was complete theft happened, where I was the only one, where no loan was issued and no coins were returned. That has been resolved. That will go in my form. And for Bank to the Future, we had, because people were asking, some of our operational funds, which is the top claim. And also, as everyone knows, we were working on a security law compliant version of Celsius, which we put into beta. I was the biggest beta customer. About 90% of it was me as the customer. And we had some of our high net worth investors that were part of our securities law compliant version that we were creating in beta. And that led to the second claim. The third claim is my personal claim. And I've explained this 100 times, but just so I've got it in one place so everybody can see that. So I'm now the 7th largest creditor, but also we have the different entities there. And shareholders will be submitting their claims. So look how Alex Mashinsky has filed his shareholder claim. The Series B will be doing the same. And so there will be, all of the shareholders will likely be filing their claims. And then everything gets resolved in the court. And it may be a big nothing burger because it all depends upon how those intercompany loans were structured and whether the assets were less than those intercompany loans or more. And so that all gets determined in court so everybody can understand. Plan still moves forward. Custody still go through settlement. Withhold still go through settlement. Borrowers still go through the next iteration of their settlement. And then we have a competitive stalking horse process next. Now, does this turn into a criminal case? Well, obviously last week, Do Kwon was arrested for, I think, a lot less misrepresentations. And we're also seeing many of the legal cases coming through. And so obviously that becomes important when we're putting together our claim forms, because at the moment they're going to be civil claims, again, not a lawyer. And depending on what happens next with any of the criminal cases based upon the fraud and misrepresentations, because we've all obviously got to put it in our claim form, and these frauds may be criminal cases. That goes to the litigation trust. And so our recovery really becomes an important outcome for after Chapter 11 as a result of these cases. Okay, So it all becomes important and it all ties back. So now we can understand much of the history and obviously why there are people out there trying to protect Alex Mashinsky's reputation. Again, not legal advice, in order to try and make sure that these relationships, and I'm just trying to put it all throughout there. So I'm going to now head over to a Twitter space. Sorry again that I was shaky. Let me put my face up before we end. Again, sorry that was a little bit shaky with my voice. I tried to explain very complex subjects. There's more to it. None of it should be treated as legal advice. I'm not a lawyer. I'm just trying to unpack this for creditors so they can then discuss it with their lawyers. The UCC does a town hall on Thursday, and I'll keep giving updates as the court process unwinds. But at least I hope that this furthers people education on where shareholders stand right now, the different misrepresentations, what happens next, the importance of the court settlements in Chapter 11, and then the litigation trust. And if anyone wants to ask any questions, and I'm going to head over to Twitter Spaces right now, and there'll be a bunch of other creditors so that we can unpack this. And I just really nothing I can do about it, but we have to all file claim forms now. It is no longer enough. And remember David Adler, he said, luckily that bar date was extended because now everybody needs to do that. So please, if you know any creditor or any shareholder or anyone that was involved in this, please make sure they get this video, because we're talking to a much, much smaller group than the entire 600,000 creditors. And we'll publish this to the shareholders through Bank to the Future as well, just so that everybody understands where they stand and they get their forms in. At least they have all the information that they need, because now it's got very complex. So please like this, please share this with anyone you know that's a creditor, and let them know that it's vitally important to pay attention in how they set their claim forms, because now it will affect the likely recovery, because we don't know where this goes next and it all gets settled. So I hope that was useful information. We've got, do attend the Twitter spaces that I will be doing, because we'll crowdsource more and more information and creditors helping other creditors, and we'll publish more information as well to those shareholders as well. Okay, all right, well, I'm going to go head over to Twitter spaces. Hopefully my voice survives. I'll take a quick water break and I'll see you over there. Peace, love, unity, and peace.